Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable James A. Edwards, Chief Judge, presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, this honorable court. Please be seated.
Good morning, everybody. Welcome to a session of oral arguments here. For the 5th, we have 2 in person. We've got a lot of people here today. That's amazing turnout for 2 oral arguments. And then we have a Zoom argument later today. I've already been introduced. To my right is Judge Harris, and to my left is Judge Soud. If you have noisemakers, please turn them to silent. And I'm going to do the same thing now, because they will go off at the worst possible time. We got supplemental authority from appellee this morning because it was filed after 5 o'clock on Friday. So if y'all could keep that in mind, we decided not to wait the oral argument while we read the 10 cases that were filed. We decided to go ahead. So whatever they say, good. We haven't read them. We'll have to read them later. So please, in the future, keep that in mind, everybody. Everybody out in TV land, too. We're happy to read things. There are differing opinions on supplemental authority that's not real recent, but that's beside the fact. We can't read it if we don't get it. So, all right. Our first case this morning is 23-3766. Michelle Cook is the personal representative of the estate of Richard Cook versus CSX Transportation, Inc. Just to explain our setup here, if you're not familiar with it, we have green, yellow, and red lights, just like traffic lights. When you get to yellow for the appellant, that means you are into your rebuttal time. You have total 20 minutes per side. You don't get 20 minutes and then 5 more minutes. Sometimes people seem to get confused about that. If it looks like you're not paying attention to the lights, I may give you a little jab to let you know. If you want something other than 5 minutes, that's fine too. Just tell me and we can do that. So, with that, appellant may proceed.
May it please the court. I'm Jonathan Sternberg, and I represent the appellant Michelle Cook, who, as your honors know, is the widow of the decedent Richard Cook. As your honors also know, Mrs. Cook appeals from a summary judgment in favor of the CSX Railroad on her wrongful death negligence claim under the FELA. The trial court excluded her medical causation expert, Dr. Mark Levin, holding Dr. Levin's testimony that Mr. Cook's substantial exposure to the carcinogens diesel exhaust, benzene, and glyphosate during his railroad work was a likely cause of his multiple myeloma and leukemia was inadmissible under the Daubert standard. And because Mrs. Cook, of course, then had no medical causation expert, the trial court granted summary judgment to the railroad. Your honors, excluding Dr. Levin and therefore granting the railroad summary judgment was error. This court should reverse the trial court's judgment and remand this case for trial. The trial court fundamentally misapplied the liberal admissions standards under Florida Statute 90.702 as interpreted in the Daubert case and its many progeny in this and other courts throughout the country. This is because Dr. Levin used information he was given, particularly from Mrs. Cook's liability expert, Dr. Paul Rosenfeld, who was neither challenged, let alone excluded, and then used standard, well-accepted methodologies to reach his conclusion. First, he reviewed scientific literature using his expertise as informed by the Bradford Hill criteria. Here, notably, that literature included monographs and other studies from the International Association for the Research of Cancer, the National Toxicology Program, and the EPA, and others, concluding that diesel exhaust, benzene, and glyphosate are carcinogenic and cause myeloid cancers like Mr. Cook's. He then used a differential diagnosis, which is a standard methodology to determine causation in toxic exposure cases like this, to come to a conclusion that Mr. Cook's substantial exposures to these carcinogens during his railroad work was a likely cause of his myeloid cancers. Under Daubert...
Did Dr. Levin do any analysis of the dose exposure that Mr. Cook had?
He relied on Dr. Rosenfeld's report for that. The railroad uses the term dose, and the trial court used the term dose. But what we're really talking about in a toxic exposure case is not a definitive quantifiable dose and a definitive quantifiable threshold, but rather, as in the Northrop case from the 3rd District in 2017, which was about asbestos exposure and used these same sort of ideas, whether there's evidence of a substantial exposure of the sort that causes cancer, and an expert can reliably testify that as a result it's a likely cause here.
Does anything else cause mesothelioma other than exposure to asbestos?
I don't know, Your Honor. That's not one of the toxins at issue in this case.
I understand that, but in the asbestos case you just mentioned, mesothelioma, I believe, has as its cause asbestos exposure. I may be incorrect.
I believe that is a
Whereas
cause.
multiple myeloma is often idiosyncratic, isn't it?
Idiopathic, I mean, it has lots of different
sorry.
causes. Dr. Levin testified it has lots of different possible causes, which is why he couldn't rule out anything, he couldn't rule out everything, but he couldn't say that despite his failure to do that, this wasn't still a likely cause. Remember, this is a FELA case, and so the standard of causation under FELA is much lower than a normal case.
Well, you still have to prove that it's a cause.
Certainly, absolutely. But so here, the substantial exposure is in Dr. Rosenfeld's report, which again was never challenged at all, and is something, therefore, on which Dr. Levin can certainly rely. And this is on pages 384 to 400 of the record. He explains that using methodology, this is Dr. Rosenfeld, from the EPA and the risk assessment system, he was able to estimate the level of Mr. Cook's exposure to diesel particulate matter during his during his career, which is synonymous with diesel exhaust. From this, he was able to mathematically determine, this is pages 386 to 99, actually 386 to 400, he was able to mathematically determine Mr. Cook's exposures to diesel exhaust. So Dr. Levin himself didn't have to do some separate study. He can certainly rely on this, because one of the Daubert factors is the facts from which the expert draws his conclusion. Here, the fact is from Dr. Rosenfeld's own estimation, which was never challenged and not excluded. And so Dr. Rosenfeld concluded that Mr. Cook was exposed to significant and above background levels of locomotive diesel exhaust while working in tunnels, as well as benzene, as well as glyphosate. So from that, Daubert is concerned with a reliable methodology, not challenges to how an expert applies that methodology. So as long as the expert uses a reliable methodology, as a matter of law, challenges to how he applied that go to the weight of his testimony and not its admissibility. As Florida courts, the 11th Circuit, and other courts have held many times, including in the Northrop case I mentioned, which, yes, was about asbestos, but also the Castillo case from the Florida Supreme Court in 2003, and the Dumigan case from this court in 2022, which I'll note, Judge Harris, you joined. Reliable methodologies include reviewing scientific literature, using expertise and the Bradford Hill criteria in doing so, and a differential diagnosis, ruling in possible causes and ruling out some. That's exactly what Dr. Levin did here. First, he reviewed scientific literature using his expertise, as informed by the Bradford Hill criteria, to arrive at a general causation opinion that exposure to diesel exhaust, benzene, and glyphosate causes myeloid cancers. It is a cause of myeloid cancers. As the IARC, the NTP, the EPA have all determined, using Bradford Hill criteria themselves in doing so, which Dr. Levin testified, exposure to these carcinogens causes myeloid cancer.
Any exposure?
Excuse me?
Just any exposure? Any level?
No, it has to be a substantial exposure. And here, Dr. Rosenfeld found the exposure itself was substantial enough.
In terms of Dr. Levin, he didn't himself make any comparison between Mr. Cook's exposure to whatever amount of benzene is in diesel exhaust to the exposure of benzene in the studies, correct?
He himself didn't make his own separate study of it. No, he relied
said,
on
in fact,
Dr.
it was not possible to do so. So if you can't compare his exposure, and I'm looking at record 587,
Okay.
and if I could, folks, again, please don't file those 4-page depot transcripts to a page. Those are really hard to read. But anyhow, I mean, and this is at page 24 of the hearing transcript, I believe. He said it was not possible to compare Mr. Cook's exposure as far as benzene and diesel exhaust to the benzene exposure in the literature that he said was relevant. So how is the literature relevant if it doesn't compare to his exposure?
Sure. So two answers to that. First, the literature he's relying on states that substantial exposure can cause this cancer. We're dealing with general causation at this point. We're not specific causation yet. Dr. Rosenfeld, in his report, on which, again, Dr. Levin can rely, says that the level that Mr. Cook experienced was to that level that causes cancer.
Because he got cancer.
No, that's not why at all. No. So in his report, Dr. Rosenfeld uses this risk assessment system. So in cases like this, you're never going to have a situation where, he worked for the railroad from the 1980s to the mid-2000s, that the railroad measured the diesel particulate matter and that sort of thing. There's a case we cite from the Tennessee Supreme Court, Payne, which synthesizes other authorities, and they say it's fundamentally unfair to require us to produce a precise exposure data when the railroad itself didn't do that. Instead, what we do is we rely on proxy studies. And Dr. Rosenfeld, as the industrial hygienist expert here, performed one of those proxy studies. And it's not just because he got cancer. It's because the level that he experienced, the level that from his coworker, Mr. Williams' statements that Dr. Rosenfeld had interviewed and had synthesized in his report, that this level, that he was able to mathematically determine that these exposures to diesel exhaust resulted in a heightened cancer risk. So then relying on studies from the IARC, EPA, NTP, et cetera, Dr. Levin's able to say, well, he had that amount of risk, and these are things that cause cancer. He had that level that can increase your cancer risk. Therefore, it's reasonable that this was a likely cause of his cancer. So that's general causation. That's the Bradford Hill criteria. Now, of course, the railroad's expert disagrees, right? The railroad's expert says these aren't statistically significant enough. Dr. Levin disagrees with that. He says no, and it goes through a lengthy explanation in his testimony and report why this was statistically significant. The bottom line, though, is the jury wouldn't have to go with the railroad's expert, Dr. Pyatt. A jury could instead agree with Dr. Levin and the authorities on which he relied and disagree with the railroad's expert. That's the Payne case from the 2nd District in 2022, where they talk about a battle of experts, where you have two experts with differing conclusions from the same basic data. It's up to the jury. We don't, while the trial court has a gatekeeper function under the Daubert test, that gatekeeper function does not accord to weighing the evidence. And here, that's the jury's job. So that's general causation. Then for specific causation, Dr. Levin used a differential diagnosis and properly ruled in Mr. Cook's exposures during his railroad work as a likely cause of the cancers. And this was, again, of course, from Dr. Rosenfeld's report. And if you go through Dr. Rosenfeld's report, it's, especially from Mr. Williams' statements, it's pretty damning. He talks about in tunnels, including one that took 30 to 45 minutes to traverse, they could always smell diesel exhaust. Now, my client was not a smoker, but other people in the trains were, and they would have to open the windows so he could, let people smoke out the windows so as not to be inundated with smoke. Also, there was no air conditioning, and this, of course, is Florida, North Carolina, and Georgia, South Carolina. It's very hot. And so they'd have to open the windows in the tunnels, and the crews would be inundated with diesel exhaust. They'd have to evacuate trains in the tunnels sometimes because of this. They'd also spend 30 to 40 minutes at the beginning of each day's shift with next to these idling locomotives spewing black exhaust, he says. And they also rode on spray trains that Dr. Rosenfeld was able to determine were spraying huge amounts of glyphosate herbicide. You can imagine these cars that have large tankers, and on the top are these sprays, and that's what they're doing. Those are herbicides. Given all of this, Dr. Levin could easily rule in Mr. Cook's railroad exposures as possible causes of the myeloid cancers. Again, I appreciate the defendant's expert disagrees, but that's why the defendants get to have their own experts, because the jury gets to hear both experts, and the jury gets to determine who they believe and who they don't believe. In the Holland case, which Judge Edwards, you wrote just the other year, that also reversed the exclusion of a Daubert, of an expert under Daubert, one of the things Your Honor said is this is fodder for intense cross-examination. It's fodder for the defense to have their own experts. It is not fodder to exclude our expert. So he rules in the cancer-causing benzene, diesel exhaust, and glyphosate. And then he also rules in some other things. Smoking, family history, age, radiation exposure, possible other occupational exposures, but he was able to rule out smoking. Mr. Cook was never a smoker. Family history, age, radiation, was never around that, and other occupational exposures. What we come down to is he couldn't definitively rule out, and he admitted this, secondhand smoke exposure, as I mentioned before, and obesity, and just general idiopathic causes. But as courts have held many times, including the Gwynn case from the 11th Circuit in 2010, the law didn't require him to rule out every single other possible cause in order for his opinion to be admissible. Again, that goes to weight and not admissibility. And especially here, unlike the cases the trial court cites, which I'll note the appellees don't actually try to defend in their brief, he testified this didn't change his conclusion. He openly admitted he couldn't rule out these potential other things. But he said the nature, this is on page 1815 of the record where he testifies to this at the hearing, as the nature of multiple myeloma is that it isn't from a sole cause and instead is from these multiple causes. And here, in a FELA case where we don't have to apportion fault or damages between railroad and non-railroad causes, it doesn't actually make a difference. As Florida courts have observed many times, including in many of the decisions reversing Daubert exclusions on pages 30 to 33 of our initial brief, the concerns the railroad raised as to Dr. Levin's lack of information about the exact amounts of Mr. Cook's exposures, their experts' criticisms of how he applied his reliable methodologies, or his inability to rule out some other possible causes, all go to the weight of his testimony and not its admissibility. Dr. Levin, simply put, used well-established, reliable methodologies, and they're challenging how he applied those, not the methodologies themselves. The trial court was wrong to hold, as a matter of law, this isn't just an abuse of discretion. Discretion has to be informed by, an exercise of discretion has to be informed by the relevant legal standards. And here, under the relevant legal standards, the trial court was wrong to hold that this in any way made Dr. Levin's testimony inadmissible under Daubert. We would ask your honors to reverse the trial court's exclusion of Dr. Levin, and as a result, its summary judgment in favor of the railroad.
All right, thanks.
Thank you, your honors.
Got about 5.5 minutes for your rebuttal.
Thank you, your honor.
May it please the court. Frank Gordon for the defendant appellee here. Chief Judge Edwards, I'm going to start where you started. I want to talk about this notice of supplemental authority that we filed on Friday. We realized last week preparing for this argument that there are a lot of cases that most of which have been decided since the briefing that directly relate to this witness, and that's why we filed them. I can save you time regarding those 10 cases. Every single one of those cases is a case in which I think they are all state court, either trial judges or appellate courts, excluded this witness, Dr. Mark Levin of Mahwah, New Jersey, in a case in which he is attempting to claim that science shows that certain exposures at railroads in America cause all kinds of cancer. Every single one of those cases excluded this witness, which brings that total to, counting the 5 that we cited in our brief from other states, 15 trial courts or appellate courts in the last 3 or 4 years have excluded this witness on the exact issue before this court today. Did this witness apply a reliable methodology? He did. In a scientifically reliable way? He did not. And that, we believe, is why Judge Aho excluded this witness from testifying in this case, and that's why her opinion should be affirmed. And let me just talk about those briefly, Your Honor. One of them is the Murray case. I think that one is actually cited in our brief. That's throat cancer, New Jersey. Dr. Levin excluded because his methodology, his application of a reliable methodology, the Bradford Hill methodology, is not reliable. It's not scientific. Arnn, a very lengthy opinion from Judge Bruce Anderson, is in one of the supplemental authorities. Judge Bruce Anderson from Duval County, of course, who excluded this witness, Dr. Mark Levin, in a case against our client, CSX, in which Dr. Levin was trying to testify that working at the railroad, diesel exhaust primarily, the benzene in diesel exhaust, perhaps herbicides too, cause acute myeloid leukemia.
Let's focus on this case rather
sir.
than the supplemental authorities
sir.
that we haven't looked at yet.
There's, just briefly, there's 3 other judges from Duval County that are in the supplemental authority, same exact type of opinion. In this case, Your Honor, first let me start briefly with the standard of review. I think it's pretty obvious that abuse of discretion is a standard of review for a decision about the admissibility of evidence, of course. There is case law in this state, of course, the Pantoja case, McCrae, and Pang that point out the fact that there is a de novo standard of review if the trial judge plainly applied the wrong law. I think, for example, in McCrae, the trial judge ruled that a witness's recollection could not be refreshed because the evidence that the lawyer wanted to use had hearsay in it, and apparently the rule is clear in Florida that that's okay. The trial judge didn't allow it. De novo review, that was an error by the trial
That discretion is cabined, of course, by the evidence code. You would agree?
Yes, sir, absolutely. And so here I think what we're talking about is an abuse of discretion standard, which this court knows is considerably deferential. Apparently their argument as to what I didn't hear it just a minute ago, but in the brief, the argument that Judge Aho misapplied some law apparently is that she did not take into account the modified standard of causation under the Federal Employers Liability Act. And that's plainly not the law. We've cited to the court in our brief, on page 13 in our brief, the Ninth Circuit in Clark, C-L-A-A-R, Sixth Circuit in Taylor, Second Circuit in Wills. All of them say the standard of causation under the FELA and the standards for admission of expert testimony under the federal rules of evidence are distinct issues and do not affect one another. And really, to say otherwise doesn't make sense. You know, the first question for the court to decide, the trial court, is this testimony admissible? And that's a question of evidence law. That's a question of reliability in this type of, with an expert witness talking about scientific evidence. Is this testimony, is this methodology scientifically reliable, and has it been applied in a scientifically reliable way? And it's plain that the case law doesn't support any other reading of the intersection between Daubert or any other evidentiary standard and the federal
Counsel,
employers.
you would agree that if Dr. Levin had gone through and done everything properly in terms of his analysis, came up with an opinion that he could support, that this was a cause or one of several causes even of the multiple myeloma under FELA, that would be admissible?
Absolutely.
He doesn't have to prove it's the only cause.
No, sir. No, and honestly, I don't think the FELA is unique. Every state has tort law that says there can be more than one cause of a tort, an injury. So, but that's just not what he did here, and I think it's pretty obvious. And the reason that the plaintiffs say it should be differently is they cite to this Hines case from the Third Circuit as the leading decision. I'm not sure I would describe it that way. It was a 1991 decision 2 years before Daubert. I don't think it's very helpful for understanding the intersection between a case that hadn't been decided yet and evidence law. Plainly, the law is otherwise. And the law here, in this case, right here today, of course, is 90.702 of the Florida Evidence Code. And the part of that statute that I don't hear discussed, it's not discussed in the appellant's brief, it wasn't discussed today before the court, and it kind of amazes me, is that the rule itself says plainly that the third prong of the rule, 702, is whether or not the reliable methodology was applied in a reliable way. I just heard the argument that challenges as to how the methodology was applied. Daubert isn't concerned with that. Yes, it is concerned with that. Every case in our brief was concerned with it because that's part of the test. It's written right into the rule. It's okay. You have to use a reliable methodology, but you have to use it in a reliable way, a scientifically legitimate way, and that is what did not happen in this case. And that brings me to the record here. So Bradford Hill methodology certainly is a reliable methodology. The idea of this Bradford Hill 9 factors is for a scientist to look at a body of literature, not just epidemiology, but all kinds of scientific literature, and say, what does all this literature tell us? What does it say? And the first 2 factors are strength of association and consistency of association. So that's what the inquiry is supposed to be about. Do I look at all this literature and does it show in a strong way, consistently, different places, different groups of people, this substance causes that cancer? Well, that's That's not true here. That's not what the literature shows. And most importantly, in terms of methodology, Dr. Levin didn't even try to look at it, all of the world's literature. And I think I can show you exactly what I mean there. First off, let me talk about where he started. He said, well, I don't know the answer to the question, so I'm going to look at the scientific literature. That's basically his database for reaching his opinion. Fine, everybody does it that way. Tell us what all did you find when you did these internet literature searches, Dr. Levin? Well, I've certainly found the cases, the studies I cited to. Well, weren't there others that you decided to cull? Yeah, but I don't know what they were. Well, what were your search terms? I don't know. Didn't write them down. Now, no one can replicate that science. That's the hallmark of reliable science. Some other scientists can replicate at least what you did. Now, they might come to a different conclusion. That's fine. But if you can't replicate what they did, it's not science at all. Statistical significance. He failed to identify a statistically significant association in the literature before even applying the Bradford Hill criteria. And why does that matter? Because the case law says that it matters. This is really on page 24 of our brief. I don't want to read the entire brief to the court. I know you all have read the brief, but you can see beginning on page 24, case after case, and a lot of this is 11th Circuit case law. We tried hard to focus on that. The first step an expert must take to establish general causation through epidemiology is to demonstrate that exposure to a substance is associated in a statistically significant way with a particular disease or adverse effect. And that did not happen here. Dr. Levin did not do that. He did not identify a statistically significant association in this literature because there isn't one to identify, frankly. But that's what you do before you even go to the Bradford Hill criteria. You start with a body of literature that has statistically significant results. Otherwise, we're just talking about chance results. That's what statistical significance is for in epidemiology, to try to eliminate the possibility to a 95-degree confidence interval, 95% confidence interval, that we're not just looking at stuff that happened by chance. That's why there's that rule. That didn't happen here. Once an association is identified, the expert has to determine whether the association represents a true cause-effect relationship between exposure and the disease. If I told you, I've noticed that people that wear bathing suits a lot seem to get a lot of skin cancer, I think it's the bathing suits. And we all know that's stupid. I would be wrong. But there is a statistically significant association between wearing bathing suits and getting skin cancer, even though we'll look at it and figure out it wasn't the bathing suits that caused the skin cancer. But there is a statistically significant association, and you have to identify that first before you even go look at it further. And so, as the courts say, this is the sine qua non of general causation. The second step of determining whether an observed association represents true causation may be carried out by employing 9 well-established factors known in the scientific community as the Bradford Hill criteria. So he skipped step 1. And the courts say, with respect to that, well, they say studies that do not represent statistically significant results do not provide a reliable foundation for a general causation opinion in a toxic tort case. And I was curious to see, maybe in the reply brief, what the appellants would say about the substantial law that occupies the bulk of our brief. And what they said about it was nothing. Nothing. They haven't responded to this law. And, well, there's not a lot of contrary law. It is the law. Further on, I'm on page 26 of our brief. In excluding causation expert, this is the Henry Lipitor case, federal court in South Carolina. The court emphasized that, quote, "It is well established that the Bradford Hill method used by epidemiologists requires that an association be established through studies with statistically significant results. Experts may not start at step 2, applying the Bradford Hill criteria, without adequate evidence of an association." Dr. Levin doesn't even understand that and didn't do that. There's more of the same over on to page 27. So to begin with, that hasn't been satisfied in this case. Let me just touch on a couple other. The big point is he didn't weigh the literature. And these cases say repeatedly, starting over on page 28, you have to do that in this context. Again, no response from our opponents about this law. Starting on page 28 of our brief. under Daubert, quote, to ensure that the Bradford Hill / weight of evidence criteria is truly a methodology rather than a mere conclusion-oriented selection process, there must be a scientific method of weighting that is used and explained. There's no weighting used and explained in this record. None. Or in any of the cases attached to that supplemental authority, or any of the cases, there's 5 cases in our brief that deal with Dr. Levin. He doesn't do that. He thinks he doesn't have to do that. But the case law says that he does. An expert must assign relative importance to data using a scientific approach. Due to the substantial judgment required of an expert in weighing the data, it is crucial that the expert describe each step in the process by which he gathered and assessed the relevant scientific evidence. Conversely, an expert purporting to apply the Bradford Hill factors engages in a, quote, conclusion-oriented process, close quote, when the expert does not explain the weight assigned to each piece of evidence. Such a process is vague and in tension with first principles under Daubert because it makes it all too easy for an expert to manipulate the Bradford Hill factors to support a desired conclusion of causation, and far too hard for an ensuing expert to replicate and rigorously test the expert's analytic approach. So I could keep reading more of these, but the expert has to weigh the literature and address epidemiological evidence that is inconsistent with his or her causation opinions. That's the judge, federal judge, Northern District of Florida, in the Henry Deepwater Horizon cases. That's on page 30 of our brief. I could read more.
Let me go back to general causation
Yes,
just
sir.
a minute. I thought I understood appellant's counsel to say that some of the prestigious bodies like EPA and maybe the National Institute of Environmental Health had determined that exposure to diesel exhaust, secondhand smoke, and the components in herbicides could cause multiple myeloma. Did I misunderstand him, or?
I think I heard that, but that is not possibly true, and so I'm kind of hoping I didn't hear that. That's not true. IARC, probably the most prestigious international public health agency, international agency for research on cancer. They publish monographs on substances, usually. They'll put together, I call it a blue ribbon panel, scientists, most of whom have studied the substance that's an issue. Let's pull together all the literature. They don't do research. They gather the research that's already been done. They read the papers, and they try to, in an effort to help all public health agencies in the world, tell them, hey, this causes that, so take that into account. They've published 2 monographs on diesel exhaust, IARC has. The second, more recent one was published in 2014. It said, diesel exhaust causes lung cancer. There is a positive association, not necessarily causative, we don't know, between diesel exhaust and bladder cancer. And no other cancer got even an honorable mention like bladder. Certainly not multiple myeloma. Multiple myeloma is by and large idiopathic. Nobody knows what causes multiple myeloma. And so the National Toxicology Program is no different, EPA no different. Nobody on earth has said the kinds of things that this gentleman has said in this case and some of these other cases. There's no public health agency that would support his opinions. And frankly, if we look at the literature that he's relying on in this case, and we've summarized every study he cited us to, starting on page 4 of our brief. And it's 2 or 3 pages long. Won't read it all to you, of course, but the first study, he withdrew it. He admitted that doesn't support his conclusion. That was Semioticki, 1987. American Cancer Society was not even a study. The Buffetta case was not statistically significant. Dury, a blog post. Wang, 2019, glyphosate in drinking water in mice might cause them some type of problem. He cites a couple of review studies of multiple myeloma that say, this is entitled Multiple Myeloma, a review of the epidemiologic literature. The authors of this literature review study concluded that, quote, the etiology of multiple myeloma is unknown. This is his literature that he said he relied on to come to the exact opposite opinion. With no established lifestyle, occupational, or environmental risk factors, they further concluded that epidemiological evidence does not support a causal relationship between benzene exposure and multiple myeloma, as cohort and case control studies have not indicated consistently elevated relative risk, and there's no evidence of a significant exposure response pattern, and there's no significant association of risk of multiple myeloma with exposure to diesel exhaust or engine exhaust. None of these studies support his opinion. The IARC monograph 105 is the last one we've listed. I mean, it's absurd that this witness thinks, here's what I relied on. This witness is living in Fry, is what it amounts to. He thinks because he has a degree, he's an oncologist, he looked at a couple of studies and said, you know, I think it does. So I'm going to say it. That's what he did. He thinks he's living in a Fry world, but we know it's not a Fry world, not in Florida anymore. So that is the heart of this appeal. This witness did not do any of the things that the case law says you're supposed to do if you're going to look at literature like this. He didn't do any of it. And then let me just touch on a couple of other things quickly. He has no explanation for why his opinion is inconsistent with the rest of the scientific world. The case law requires you to have one if you're going to go out on a limb like that. It's okay. If you look at the same literature as everyone else and come to a different conclusion, okay, that's fine. I want to say one other thing. In the appendix to our brief on pages 3, 4, and 5, and 6 of the appendix, the rest of the world's literature is summarized on those pages, uncontestedly summarized. They're charts, multiple myeloma and diesel exhaust exposure. 36 studies that said no, don't see that here. 2 said yes and 1 said maybe. Multiple myeloma and herbicide exposure, that's page 4 of the appendix. 54 studies said no. 2 said yes and 2 said maybe. Multiple myeloma and, railroad workers, multiple myeloma risk in railroad workers. You would think that would be a good bit of literature to study. 30 of these studies said no, and 2 said yes.
Does that go to weight? Does
sorry?
that go to weight?
No, sir, it doesn't. And the reason it doesn't is because thank you, that was my last point. The federal rules of evidence were amended in December 23, just last year. And in the notes, the amendment was to add in, it is more likely than not that the witness has followed a reliable methodology in a reliable way to make it clear to trial courts, and I'll quote from the notes of the advisory committee, note 1, many courts have held that critical questions of the sufficiency of an expert's basis and the application of the expert's methodology, that's this case, are questions of weight and not admissibility. These rulings are an incorrect application of Rules 702 and 104A. The reason is because those are issues for the court to decide, evidentiary issues, to a standard under 104 more likely than not the jury. Is it reliable? Is it applied in a reliable way? The answers in this case are resoundingly no. Thank you very much. We ask that the court affirm the trial court in this case.
All right, thank you.
Please the court. You just heard what sounds like a pretty good cross-examination of Dr. Levin if we were to go to trial. The problem with what most of the court just heard is almost all of it is from the defendant's expert, Dr. Pyatt. Dr. Levin explained in detail in his testimony why he disagreed with the studies on which Dr. Pyatt relied.
Counsel, let me go back.
Yes, Your Honor.
To the question I asked about the different prestigious agencies, bodies, whatever
Yes.
they are. The National Toxicology Program, the NTP, the EPA, and the National Institute of Environmental Health. According to what I read in Dr. Levin's testimony, he admitted that none of those bodies said that there was a cause-effect relationship between diesel exhaust, secondhand smoke, and herbicides in terms of causing multiple myeloma. Am I incorrect in what he testified to?
No, you're not incorrect exactly. What he testified was
What
about...
were you telling me before about EPA said it did cause cancer generally, but not multiple myeloma? Is that what you're saying?
Myeloid cancers. So multiple myeloma is a form of myeloid cancer. It's one of a species of many, another of which, because Mr. Cook didn't just have multiple myeloma, he also developed myeloid leukemia. And one of the studies that he relied on, and it's this monograph from the IARC in 2014, it's on page 363 of the record, it's cited in his report, stated that benzene and diesel exhaust were causes acute myeloid leukemia, which is one of the things that Mr. Cook unfortunately had, as well as other forms of myeloid cancers. It doesn't say multiple myeloma, which is another the form of cancer he's had, but these are myeloid cancers. And he explained in detail in his testimony how he was able to draw from that and from a meta-analysis of other literature. This is in great detail from pages 1799 to 1809, pages 1904 to 1919 of the record, that he could perform a meta-analysis of this and come to that conclusion that multiple myeloma, a species of myeloid cancer, also had that same causal relationship. Now, but again, all of the criticisms that the court just heard were really from Dr. Pyatt, the defendant's expert. Dr. Pyatt was the one who said these aren't statistically significant studies. Dr. Pyatt was the one who said that, well, he should have kept track of his search terms. Although, actually, I think Dr. Pyatt ultimately went back on that and said, well, Bradford Hill doesn't actually require him to do that. In his own testimony, though, Dr. Levin pushed back on all of that. And he explained why the sources he cited showed that exposures to these toxins at issue cause myeloid cancers, and from that one can glean that they cause multiple myeloma, including statistically significant studies and those among railroad workers. Obviously, they have studies to the contrary, and he also went over those studies and explained why he disagreed with them. He said he didn't cherry pick anything. He simply he cited studies that came to a contrary opinion and discussed why they didn't change his conclusion. This isn't a Fry world. This is Daubert. He's using a standard accepted methodology. He is explaining how he can apply this. The defendants rely on their own expert to counter that, which they're certainly allowed to do. That's part of our adversarial system here. But it's not the same thing as this bathing suits example. That was very well done. If the IARC said wearing bathing suits likely causes skin cancer, and an expert said, well, in a FILA case, this person got skin cancer because they were outside too long, but they were also wearing a bathing suit, then that would be this case. But this isn't the same thing as just a lack of correlation of any kind. I want to briefly touch on the standard of review. The issue here is whether the trial court's 4 legal conclusions it came to were correct. Its criticism of studies on which our expert relied as not being statistically significant, the fact he didn't keep search records, the fact he didn't identify the exact level, the dose, if you will, which I note my opponent didn't talk about at all, and that he didn't rule out idiopathic causes. The problem with the trial court's judgment is that all 4 of those conclusions, that goes to admissibility, are legally erroneous. All 4 of these conclusions go to the weight of the evidence and not admissibility. And that's the legal error. It's not just a question of, I didn't read the evidence code correctly. It's about interpretation of case law. That's the Magical Cruise Lines opinion, which Judge Edwards, you joined the other year as well, goes into that too. That whether the interpretation of case law was correct is for de novo review for this court, because if the trial court excluded a witness due to its erroneous interpretation of the relevant legal standards, which is what happened here, that equates to an abuse of discretion. And of course, the legal standards themselves are reviewed de novo. Everything the court just heard is about weight and not admissibility. We'd urge the court to reverse the trial court's judgment and remand this case for trial.
All right, thank you very much.
Thank you.